Thanks to our lawsuit in the 7th Circuit, where we're fighting Illinois' unconstitutional ban on semi-automatic rifles, the Supreme Court has indicated that they're ready and willing to take up an assault weapons ban case. Today on Law and Ammo, we're going to talk about a case that GOA has recently supported with an amicus brief, Snope v. Brown, which is challenging Maryland's unconstitutional ban on certain semi-automatic firearms. GOA has supported SCOTUS taking up this case with an amicus or friend of the court brief of our own. All that and more coming up. I'm Phil and you're watching Law and Ammo. But before we get into the video, I want to take a second and challenge you to get 2 of your gun-owning friends to register to vote in this upcoming election. You're watching this video, so the likelihood that you're registered to vote is pretty high. So that's why GOA is asking our members and subscribers to get out, register their friends, and make sure that they show up to the polls this November. You may have heard the statistic that there are 10 million gun owners that aren't registered to vote. If just 3% of those people decided this November to get out and vote, they could swing the election in any direction they chose. The mentality that my vote just doesn't matter or the system is rigged is meant to keep you from voting. If you don't vote, if you don't participate and fight for your rights, the anti-gunners win. And this election will be a close one, likely decided on very slim margins. We need you to get involved. Gun owners have a massive amount of power politically, but only if we show up and vote. Don't take it from me, here's Brandon Herrera.
You hear a lot when you get mailing advertisements and things like that. You get mailers, you get hit with Instagram ads, you get hit with all the traditional media saying you need to get out and vote, and your effort really matters. And having you guys block walk for us and do door knocking and volunteering is really critical to our effort, and you just kind of tune it out, right? I will tell you, I have never been a bigger believer that stuff matters than I am right now. Everybody needs to get involved. This is all of our fight. A lot of people are willing to say, stuff about, take it from my cold dead hands. None of that stuff matters if you don't get involved now. If you're willing to give your life for it, you should be able to give 10 minutes of your time for it. And I firmly believe that.
So like Brandon said, let's take some time and get our friends to vote. Their votes matter. Your votes matter. And let's vote to protect the Second Amendment this November. Now back to the video. Currently the case Snope v. Brown sits before the Supreme Court. As of the recording of this video, the High Court hasn't taken it up yet, but there's a chance they might. Over the course of this video, I'll explain why that is and how GOA has played a crucial part in developing the legal environment for challenges like this to succeed. So what is Snope v. Brown challenging? Well, that would be none other than Maryland's assault weapon ban. In response to the Sandy Hook shooting and other shootings that made headlines in the early 2010s, Maryland politicians decided to write legislation to ban what they called assault weapons in the state. And on May 16, 2013, Maryland passed Senate Bill 281, or the Firearms Safety Act of 2013, and it was signed into law by Governor Martin O'Malley. The Firearms Safety Act bans some firearms by name, and others as copycat weapons. Those are defined as a semi-automatic centerfire rifle that has 2 of the following: a folding stock, a grenade launcher, a flash hider. Any semi-automatic rifle with a fixed magazine of over 10 rounds or has an overall length shorter than 29 inches is also banned. Those who purchased banned weapons prior to the law going into effect were allowed to keep them without registering with the state, a rare exception to the current trend of assault weapons bans in other states like Illinois. Immediately after the law went into effect, state organizations like Maryland Shall Issue, the Maryland State Rifle Pistol Association, local FFLs, and individuals all sued the state of Maryland to stop the law. The lawsuit was called Colby v. O'Malley and later became Colby v. Hogan after Larry Hogan, a Republican, was elected governor of Maryland. Colby v. O'Malley was filed in federal court in the Federal District of Maryland, the state's only federal district. In the proceedings at the district level, the district court applied what's known as intermediate scrutiny to the assault weapon ban. Intermediate scrutiny is a legal test that says if a law furthers an important government interest by means substantially related to that interest, then the law is constitutional. That test was made up by the courts to apply to the First Amendment and has absolutely nothing to do with the Constitution or the Second Amendment, but we'll get to that in a second. Of course, Maryland gun owners appealed to the Fourth Circuit of Appeals, where they were assigned a panel of 3 judges. William B. Traxler Jr., a Bill Clinton appointee, Robert B. King, another Bill Clinton appointee, and G. Stephen Agee, a George W. Bush appointee. In a 2-to-1 decision, the panel of judges found that the ban was unconstitutional and vacated the lower court's decision. Judge Traxler and Judge Agee both agreed that the provisions were subject to what's known as strict scrutiny under the Second Amendment instead of intermediate scrutiny that the lower court had applied. Strict scrutiny is another court-made test for the First Amendment, just like intermediate scrutiny, but it has a bit stricter guidelines for the judges to follow. Just make a mental note of that. Now, after the panel's decision, the case was appealed to an en banc panel. An en banc panel is where all the judges on a particular court hear the case. The en banc panel overturned the 3-judge panel's ruling, saying that not only was the ban constitutional, but it was also consistent with the Heller decision because the banned weapons were weapons of war. We conclude, contrary to the now vacated decision of the prior panel, that the banned assault weapons and large capacity magazines are not protected by the Second Amendment. That is, we are convinced that the banned assault weapons and large capacity magazines are among those arms that are like M16 rifles, weapons that are most useful in military service, which the Heller court singled out as being beyond the Second Amendment's reach. But that's not all. The en banc panel went even further to cement the Maryland assault weapons ban as lawful, saying, nevertheless, we also find it prudent to rule that even if the banned assault weapons and large capacity magazines are somehow entitled to the Second Amendment's protection, the district court properly subjected the FSA to intermediate scrutiny and correctly upheld it as constitutional under that standard of review. Essentially, the court said, even if we're wrong, you can't do anything about it because intermediate scrutiny holds this law in place no matter what. That should be a big red flag to gun owners and give you a hint as to why strict scrutiny and intermediate scrutiny are unconstitutional tests for the Second Amendment. After this, Colby v. Hogan was appealed to the Supreme Court. GOA supported the case then with an amicus brief, but unfortunately, the case was denied in November of 2017. But that wasn't the end of this particular fight. In December of 2020, Dominic Bianchi, David Snope, and Micah Schaefer, all Maryland residents, sued the Maryland Attorney General, Brian Frosch, over the decision in Colby v. Hogan. This became Bianchi v. Frosch. The plaintiffs were supported by 3 gun rights organizations: Firearms Policy Coalition, Second Amendment Foundation, and the Citizens Committee for the Right to Keep and Bear Arms. The issue at the heart of this new case was that the decision by the Colby Court to ignore the Heller decision's meaning that the protection of a constitutional right for an arm in common use for lawful purposes is outweighed in favor of the intermediate scrutiny test. The implications of Colby meant that courts could decide to ban all sorts of firearms because they may have been, quote, useful in military service, end quote. Something that is likely true of every firearm ever made. If any of this is starting to sound familiar, similar arguments were made by the 7th Circuit Court of Appeals in our assault weapons ban case. But we'll get back to that in a few. So the district court in Maryland rejected the new lawsuit, holding that there was nothing wrong with the previous ruling. They dismissed the case in March of 2021. The plaintiffs then filed an appeal to the Fourth Circuit, which also dismissed their case for the same reason in September of 2021. Finally, the case was appealed to the Supreme Court, where following the Bruin decision, it was granted, vacated, and remanded, meaning that SCOTUS told the court to take what they said in Bruin and apply it to Bianchi v. Frosch. This is because the Supreme Court addressed the question of scrutiny tests in the Bruen decision, saying, since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejected that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. Heller's methodology centered on constitutional text and history. It did not invoke any means and test such as strict or intermediate scrutiny, and it expressly rejected any interest-balancing inquiry akin to intermediate scrutiny. So take note here. The Supreme Court rejected applying the First Amendment scrutiny test to Second Amendment cases. Courts are not supposed to use strict or intermediate scrutiny to uphold gun control laws. The court is basically saying that in Heller and Bruen, they used a text and history test, and that the Maryland courts must follow that. Is an assault weapons ban consistent with the text of the Second Amendment? Well, here the answer is no. You have a right to keep and bear arms, and an assault weapon is a bearable arm. The other question is it consistent with the historical tradition of firearms ownership at the nation's founding? Again, the answer is no. Contrary to Joe Biden's constant stating that you couldn't own a cannon, you could in fact own cannons, warships, Gatling guns, and high-capacity pepper box guns at the time of the founding. The founders didn't ban assault weapons, and so a ban is unconstitutional under the second step. It's worth noting that Gun Owners of America has always advocated for this text and history Second Amendment test, even when many other Republicans and pro-gun attorneys were arguing for strict scrutiny, even before the Heller and Bruen decisions. We just don't compromise. And with that, Maryland had no way to defend its assault weapons ban. The ban had been held up by intermediate scrutiny this entire time, and the Supreme Court said very plainly it was no longer allowed. And now this is where it gets fishy. After being GVR'd by the Supreme Court, Bianchi v. Frosch went to a 3-judge panel on the Fourth Circuit. Oral arguments were held December 6th, 2022, but after that, the case went silent for more than 13 months. And after the 13-month delay, judges from the court took the case from the assigned panel and granted an initial hearing en banc. Then en banc oral arguments were held on March 20th, 2024. How did this happen without an opinion from the first panel? Well, the decision recently released in August of 2024 shed some light on the goings-on in the Fourth Circuit. Here's what the court had to say. After hearing the case in December of 22, the initial panel majority reached a decision and promptly circulated a draft opinion. Yet for more than a year, no dissent was circulated. The panel thus held the proposed opinion in accordance with our custom that majority and dissenting opinions be published together. A year later, as the proposed opinion sat idle, a different panel heard arguments in United States v. Price, which also involved interpreting and applying Bruen. The Price panel quickly circulated a unanimous opinion that reached a conclusion at odds with the Bianchi majority's year-old proposed opinion. Facing two competing proposed published opinions, the court declined to let the earlier circulated opinion control. Rather, in January of 24, we invoked the once extraordinary mechanism of initial en banc review. So basically, the dissenting judge held their opinion, delaying the decision for as long as possible. When the Fourth Circuit had the ability to override the decision, they did so, negating any pro-gun win that could have occurred. This leads us to today, where Bianchi v. Frosch, now called Snope v. Brown, awaits the Supreme Court's decision on whether to hear the case. We at Gun Owners of America filed an amicus in support of the Snope case, urging the Supreme Court to take it up. And thanks to our case in the Seventh Circuit, FFLs of Illinois v. Pritzker, SCOTUS may just decide to do that. our case is challenging Illinois' assault weapons ban, and we also filed an appeal to the Supreme Court as well. The difference being that we filed an interlocutory appeal. An interlocutory appeal is an appeal that's filed when other aspects of the case are still proceeding. GOA's appeal was denied, but a rare statement by the court in July of 24 revealed that SCOTUS felt that the Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived, non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. GOA's case was denied, as stated by Justice Thomas, because the court is rightly wary of taking cases in an interlocutory position. But Bianchi v. Frosch, or Brown v. Snope, as it's now known, is not in an interlocutory posture. In fact, the Fourth Circuit just ruled and once again upheld Maryland's assault weapon ban in a very similar manner to our case in Illinois. The Fourth Circuit said in their decision, with the respectful consideration and benefit of Bruin, we now uphold the judgment below. The assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Moreover, the Maryland law fits comfortably within our nation's tradition of firearms regulation. It is but another example of a state regulating excessively dangerous weapons once their incompatibility with a lawful and safe society becomes apparent, while nonetheless preserving avenues for armed self-defense. That sounds very similar to the Seventh Circuit's decision in our case. We find that the distinction between military and civilian weaponry to be useful for Bruin's second step too. Both the states and the federal government have long contemplated that the military and law enforcement may have access to especially dangerous weapons, and that civilian ownership of those weapons be restricted. While the Supreme Court hasn't taken up Snope v. Brown as of yet, thanks to our case in the Seventh Circuit, we know that they're open to hearing a case about this subject. And so for now, we'll be doing everything we can to support this case, others like it, and our own case against assault weapons bans across the country. And now we want to hear from you. Do you think the Supreme Court will take up this case? Leave a comment below and let us know why you think yes or no. Thanks for watching.